All right, so come here real quick. I want to show you this. So here's the deal. Basically, back in the day, we were reviewing this claim and we're going through essentially CDI units, investigators, ROI reports, stuff like that. But as part of this brief, the SSA brought forth essentially their liar test. And what is the liar test? Well, the liar test is basically, it's a case, and it originally, I'll show you exactly where it came from. It starts, and it's actually from many cases, but one of them to check out is Schultz v. Estru, 479 F, 3rd District, 979, 983, 2007. And then there was another one for 20 CFR 404.1529, which goes into additional tests. But the bottom line is now the SSA has a full analysis on what their lying test is for those they believe that are actually lying. And I wanted to go through what their write-up is, which is their actual statute, 404.1529, so that you have a basic understanding as to who is a liar in the eyes of the Social Security Administration. Because, you pay your whole life into these benefits, and then for the SSA to turn around and be like, you're a liar, we don't want to give them to you, that's a big thing. So you want to know what the elements are. Now, this particular test, and there's more tests, but this is the main one. This particular test has essentially, just to be very fair, has a lot of specifics for pain, because they're usually focused on like how much pain does this person actually have? Could they go and work as a result of it? Yada, yada, yada. So when I read through this, remember, it's going to bias towards pain. Let's get into it real quick. This is section 404.1529 statute, how we evaluate symptoms, including pain. And this has the test in it for whether or not they think somebody is being a liar before the Social Security Administration. Let's get into it. General. In determining whether you are disabled, we consider all your symptoms, including pain, and the extent to which your symptoms can reasonably be accepted as consistent with the objective medical evidence and other evidence. Okay, simple enough. We will consider all of your statements about your symptoms, such as pain, and any description your medical sources or non-medical sources may provide about how the symptoms affect your activities of daily living and your ability to work. Cool. However, statements about your pain or other symptoms will not alone establish that you are disabled. There must be objective medical evidence from an acceptable medical source that shows you have a medical impairment, which could reasonably be expected to produce the pain or other symptoms alleged, and that when considered with all the other evidence, including statements about the intensity and persistence of your pain or other symptoms, which may reasonably be accepted as consistent with the medical signs and laboratory findings, would lead to a conclusion that you are disabled. So put another way, there's different types of evidence. What you say is crap evidence, very low, subjective, not worth a lot. What a machine says, that a doctor is, has been calibrated, that a doctor reviews and says is accurate, very high objective evidence. So you got this sliding scale. You'll claim that you have these symptoms, and then they'll go and look at the objective evidence and the subjective evidence and see whether or not it makes sense. Okay. In evaluating the intensity and persistence of your symptoms, including pain, we will consider all of the available evidence, including your medical history, medical signs, and laboratory findings, and statements about how your symptoms affect you. We will determine the extent to which your alleged functional limitations and restrictions due to pain or other symptoms can reasonably be accepted as consistent with the medical signs and laboratory findings and other evidence to decide how your symptoms affect your ability to work. So this intro is all about the types of evidence they consider. They consider the totality of the circumstances, which is all of the stuff that's available. They go through all this stuff to go ahead and figure out, okay, all right, is this person really disabled? Are they not? Are they a fibber? Are they a liar? Need for medically determinable impairment. So what they look for here is they're looking for an impairment or combination of impairments that limits you to the point where you can't work a full-time job. That's what they're looking for here. All right. Need for medically determinable impairments, okay, MDIs, that could reasonably be expected to produce your symptoms such as pain. Your symptoms such as pain, fatigue, shortness of breath, weakness, and nervousness will not be found to affect your ability to do basic work activities unless medical signs or laboratory findings show that a medically determinable impairment is present. Medical signs and laboratory findings established by medically acceptable clinical or laboratory diagnostic techniques must show the existence of a medical impairment, which results from anatomical, physiological, or psychological abnormalities, and which could reasonably be expected to produce the pain or other symptoms alleged. So put another way, these impairments have to somehow make it so that you can't do what the average healthy person could do. Because if you could work. So a lot of you usually come at this from the point of like, I'm so disabled because I'm so severe and I feel terrible. It's not that. It's, would you feel so bad based on the medical evidence that they collect of you, right? And the machines output this and they take x-rays and the images show this. Would those tests show that you'd be bad enough to not work? I get a lot of people who call me, they're 32, they're 16, they're 25, whatever. I'm medically severely impaired. Okay, what evidence do you have? I feel terrible. That's not how it works. That's not how it works, all right? I get a lot of that. In cases decided by a state agency, which is DDS, except in disability hearings, which is OHO, there is the potential of a fully favorable, partially favorable, or unfavorable. A state agency medical or psychological consultant or other medical psychological consultant designated by the commissioner directly participates in determining whether your medically determinable impairments could reasonably be expected to produce your alleged symptoms. Because remember, they're looking to see if your medical evidence is reasonably bad for how much, whining and sighing and how terrible you believe you actually are. Because, a lot of you guys are, oh, I'm terrible, I'm horrible. But, does it actually show that? That's the important thing here. I want to do a quick shout out for Princess Diana. She did 2 donations. I'm going to be doing a specific video on Shadow. And basically, he has his upcoming surgery, which is major. It is a full hip replacement, which is a whopper, a total and complete giant extra bacon whopper of a surgery. But super thank you to her for the $2 donations. That's absolutely amazing. Very, very good. Okay, so in the disability hearing process, a medical or psychological consultant, right? So that's the doctor they send you to, or the doctor that reviews your medical documents for the SSA. A medical psychological consultant or a medical expert, right, may provide an advisory assessment to assist a disability hearing officer in determining whether your impairments could reasonably be expected to produce your alleged symptoms. At the administrative law judge hearing or appeals council level of the administrative review process, the adjudicators might ask for and consider the opinion of a medical or psychological expert considering whether your impairment could reasonably be expected to produce the alleged symptoms in limiting your ability to go ahead and do a job in the national economy. Now, we're going to skip through a lot of the stuff that's in this statute, and I'm going to get right to essentially the test that they use to figure out whether or not you are a liar. That's what they're trying to figure out. They're trying to figure out whether or not you are de facto, in this particular situation, a liar. Let's get into it. Okay, section 404.1520C explains in detail how we consider medical opinions and prior administrative medical findings about the nature and severity of your impairments and any related symptoms such as pain, factors relevant to your symptoms such as pain, which we will include the following. They'll consider the following. So this is the important part. This is the part where they're basically saying, okay, we're going to consider these factors. Here's our lie detector test to see if you're a BS artist. Okay, here we go. Okay, factors relevant to your symptoms, such as pain, which we will consider include 1, your daily activities. Are you going out fishing? Are you able to drive a car? Are you able to do your laundry? Are you able to vacuum the house? Now, people found disabled 15, 20 years ago, those people are like, of course I can. That's ridiculous. I can do those things just fine. That doesn't mean I'm disabled or not. Well, technically, it does. But when you were found disabled 15 and 20 years ago, it was much easier to be found disabled. Nowadays, many of you wouldn't be found disabled under the new regs, the rules and requirements. So as a result, they are looking to see whether or not an individual actually nowadays is unable to drive, no longer has a license, doesn't pay insurance on a car, doesn't have a title of a car in their name. Whereas, people 15, 20 years ago, they're like, of course I can drive. Of course I can. That doesn't mean I'm not disabled. Those people don't exist now. I mean, they still exist from back in the day, and they still pop up in the, the chat where they'll be like, that doesn't mean I'm not disabled. That's ridiculous. How dare this person say it? And then they'll like throw it on me. They'll be like, how dare he touch my thought patterns, But the reality of it is that the current people, they can't be found disabled in those situations. A lot of them, unless you get a real liberal judge, which there's not many of them left. The bottom line is you just, if you have, okay, so let me give you an example, right? Okay, so you live alone. Yes, Your Honor. Okay, so you live alone, and are you able to go ahead and handle your cleaning? Yes, Your Honor. Able to go ahead and do your own laundry? Yes, Your Honor. Are you able to go ahead and, handle your finances online? Well, yes, Your Honor. Well, that's all evidence as part of your daily activities that you are capable of doing a job because you didn't restrict the statements that you allowed the judge to roll you over with. Ma'am, do you have the ability to clean your house? No, Your Honor. I am restricted. I have limited abilities in that I have to I'm not able to reach up high while dusting. I'm not able to move furniture to get behind them. I'm not able to move and roll up carpets to clean under them. I'm not able to handle the weight of a vacuum as a result of my elbow and shoulder issue. I'm not able to go ahead and be around dust and other pulmonary irritants because of my sinus issue. You get it. Okay. Perfect. Also, super thank you to David Triana. He put thanks for being you, and I super appreciate it. Did a $20 donation, which is absolutely amazing. So, guys, I really love these donations, and they really kind of get me excited because I'm using a lot of it to buy gear to create the first disability focused production studio that will allow people with disabilities and impairments to create media, kind of like, America's Got Talent, The Voice, stuff like that, because there's a lot of people that would never even make it onto those programs as a result of their impairments. And I'm hoping we can use this stuff to kind of bolster and build the community so that people really have a better outlook and a better future. I want to condition people who aren't disabled to like disabled more. That's what I'm trying to do. And I'm trying to give the disabled more opportunities to have money, because I feel like if I make more people more successful in the disabled community, then they're more likely to continue to build so that other people who don't have options have options. So that's the overall goal. It's a big goal. All right, so that's factor number 1, your daily activities. Daily activities. Factor number 2, the location, duration, frequency, and intensity of your pain or other symptoms. So location, where's the pain on your body? Duration, how often do you have it in the sense of a full day? Frequency, how much do you get it? You get it back, right? Did it come back? Did it come back? Intensity, is it a 5 out of 10? Is it a 10 out of 10? They look at the location, duration, frequency, and intensity of your pain. Element 3, to see if you're, if you're flubbing, if you're lying a little bit about, essentially, how bad you are, right? Element 3, precipitating and aggravating factors. There are things that are in your environment, people that are interacting with you that make your impairments potentially worse. Are you a drug addict? Are you a smoker? Are you a drinker? Right? Is there something in your environment where you have to go up a bunch of steps that keeps making it worse? Right? Number 4, the type, dosage, effectiveness, and side effects of any medication you take or have taken to alleviate your pain or other symptoms. The type of pain medication or the type of medical impairment symptom medication, right? So are we talking about a heavy pain medication, like the stuff where like the doctor has to sign off on it and then you get a call and, they're like, we don't want to give this to you, but we're going to give it to you, but we don't want to give it to you, like that kind of stuff. The dosage, how much of it are you taking? You taking 10 milligrams, 500 milligrams? How much are you taking? Effectiveness, right? Have you told your doctors in the past that you're feeling better, getting better as a result of it? How effective is it? Next one, side effects of the medication. Tired, fog of the mind, out of it, sleepy, all over the place, not sure what to do, etc. Okay, so you look at those factors, right? The type, the dosage, the effectiveness, and the side effects of the medication you take or have taken to alleviate your pain or other symptoms. All right, element 5 of the liar test, treatment other than medication you receive or have received for relief of your pain or other symptoms. When we say treatment, there's people who are like, well, they can't treat me. There's nothing they can do. I don't have to go to the hospital anymore because I'm just disabled. There's nothing you can do about it. That's not how Social Security world works. They want to see you trying different stuff. They want to see you going and complaining about the issues you're having. They want to see medical visits to the emergency room with crisis medical treatment so that they know you are de facto actually going through whatever you can go through to show that you are the disabled person that which you claim you are because of all the pain and other symptoms that you're experiencing. So again, treatment and other medication, other than medication you receive or have received for relief of your pain or other symptoms. All right, next one, number 6. Any measures you use or have used to relieve your pain or other symptoms. In other words, lying flat on your back, standing for 15 to 20 minutes every hour, sleeping on a board. etc. The point is, they're looking for stuff that you do. And this is the main thing. I've gotten into fights with claimants that I've represented about this. I've literally gotten into fights with claimants about this where they'll tell me, I don't have to figure out anything else. I tell you that I'm disabled and severe and they need to pay me. And I'm sitting there like, dude, that is just not how this test works. That's not how Social Security benefits work. Let me read it to you again so that you're solid on it. Here's the tricky element. This is the one most of you F up on. This is the number one element you guys F up with every single one of your Social Security claims, okay? Number 6, any measures you use or have used to relieve your pain or other symptoms. In other words, lying flat on your back, standing for 15 to 20 minutes every hour, sleeping on a board, etc. Now, let me give you more of them because you guys suck at this, and I need you to understand what you need to do. Okay, buying specialty grab bars for your shower, for your house, for your apartment, okay? Buying a cane, getting prescribed a cane, getting a cane upgraded to a 4-prong cane where it has the 4 little feet on the bottom, okay? Getting a walker upgraded to a walker with a seat, hiring a service to drive you someplace because you couldn't drive that day. These are the types of evidence that give more validity to you being disabled. Because if the judge is like, okay, well, did you did you install a rope above your bed to help you pull yourself up? And you're like, no. Well, then the judge is like, well, then how do you pull yourself up if your back issues are that severe? And then the claim is, well, I just make it happen. No. I just roll off the bed. I just I Cirque du Soleil my body off the bed, and then magically I end up in my shoes in the upward position. There's a bullshit factor that a lot of you guys don't think the judges are aware of. But if you, imagine, most of you had a job, right? And then let's say somebody walked up to you at that job. I was like, yeah, I know how to do this. I've been doing this for a long time. And then they proceed to start to do your job, and they're doing it not very well. They're doing it kind of shitty. That's what you guys sound like when you don't take time to figure out element 6, the one you guys always screw up. Let me read it one more time because I think it's important, okay? All right, here we go. Any measures you use or have used to relieve your pain or other symptoms. In other words, lying flat on your back, standing for 15 to 20 minutes of every hour, sleeping on a board, having somebody come in and install a ramp to get into a room, having somebody install, ramping to get into the house, having somebody install a rope above your bed, having somebody install a rope above your toilet, having somebody install grab bars, having somebody install special things on, here's one that's smart that most of you don't do. And I don't know why you do it. I mean, it's like, for me, if I were trying to get disability benefits, it's like blinkingly obvious. If you have a problem with society, with really bad anxiety, depression, panic attacks, schizoaffective, schizophrenia, if you have those kinds of issues, PTSD, don't you think it would be wise to have a payment on file that can be used as evidence to show that the windows were covered with something that reduced what people could see looking in and limited how much light, you could see going out. So you couldn't see what was out there as well, and people couldn't see what was coming in. Don't you think that would be like a basic thing that you would get done to your room, to your house, if you had anxiety and depression and panic attacks? Not just like, you have closing blinds, but like actually something on the window. Like, to me, that's obvious. But then to most people, they're like, I never thought of that. And I'm just sitting there. I'm just like, okay, that's fine. I'm in this field. I do this law. But at the same time, if you want to win benefits now, it's not like it was 15 to 20 years ago where it's like you went to a mental facility, you told them you had anxiety, they gave you pills, 3 months later, you claim that you didn't get better, and poof, you're found disabled. That ain't how it is now. All right. I spent too much time on element 6, element 7. Element 7, other factors concerning your functional limitations and restrictions due to pain or other symptoms. That's the everything else category. That's the throw everything else in their category. All right. Now, with that said, I'm going to go through these. I'm going to read a little bit more because I think you need to understand this stuff. Here we go. These are the factors, the elements to define whether or not the SSA will believe that you're disabled or whether they think you're a BS artist and a liar. Okay. Number 1, your daily activities. what you can do, what you're currently doing. Number 2, the location, duration, frequency, and intensity of your pain or other symptoms. Number 3, precipitating and aggravating factors, things in your environment that make stuff worse. Like, are you always having to climb stairs to get into your house, and therefore you always have pain? And if you got rid of that and had a ramp, would you be better? 4, the type, the dosage, the effectiveness, and side effects of any medication you take or have taken to alleviate your pain or other symptoms. 4, the type, the dosage, the effectiveness, and side effects of any medication you take or have taken to alleviate your pain or other symptoms. 5, treatment other than medication you receive or have received for relief of your pain or other symptoms. Remember, not everything is as simple as I went to the doctor. I'm done. I got it. I'm done. Everything's done. I'm fine. Everything's great. I'm done. I don't have to do anymore. I'm done. That's not how this works. That is not how this works. Again, treatment other than medication you receive or have received for relief of your pain or other symptoms. Okay, let's say you got a back problem. Treatment, okay? You are prescribed, to go to this therapy, and they're going to go ahead and do this, this, and this. It's not working. You go and try some other treatment. You go and try some other treatment. You go and try some other treatment. Judges know if you are disabled because you keep trying to find a solution. The people who say, I don't have any money and don't end up in the emergency room, that's a massive red blinking light for judges. Because when judges see that, I don't have any money, unless that person truly does not have a vehicle, does not have a way to drive, doesn't, lived in a small town their entire life, doesn't know anything about anything, it's a major red blinking light. Because if you were really that bad, your butt would be trying to find solutions. And remember, solutions don't just come from, I went to this building, I went to that medical facility. Solutions also come in the form of things that you buy. Okay. You could buy some sort of special heating pad, some sort of grounding blanket, whatever. The attempt by you and the professional marketplace of medical professionals is what the judge is looking for. Somebody who's trying to find a solution to get back to work. Incredibly crucial. Most of you guys don't know that. All right, next one, number 6, the element you guys screw up the most. And I don't say this to be demeaning. I say it because I want you to focus on this one. Any measures you use or have used to relieve your pain or other symptoms, like flat on your back, standing for 15 to 20 minutes of every hour, sleeping on a board. I'll throw in some extra ones. Okay, some extra ones to help you. Getting prescribed a walker, getting prescribed a walker with wheels, getting prescribed a walker with wheels and a seat, getting prescribed a rolling walker with wheels, and then basically some sort of white noise thing on it so that it blocks out additional things, or whatever. The things that you use to try and make it better for you. Because when the judge sees you attempting to make your life better through using objects, through using medical devices, whatever, the judge knows you must be really bad because you're trying. If you're not trying, the judge ain't going to go that far to try and figure out, what the dealio is here, because the judge knows if you're not really trying, you must not be that bad. Unless you have an intellectual deficiency where your IQ is too low. That happens too. They take that into account as a factor. Now, with that said, if you like these videos, hit the like button. Don't be afraid to hit the like button. Hit the like button. If you want to know about disability law, if you want to know the intricacies, if you want to know how they're applying it to you, hit the like button. All right. Or subscribe, either or. Totally good. Final element. Other factors concerning your functional limitations and restrictions due to pain or other symptoms. And this is the overall catching element to see if you are a liar or truly a disabled person. Any other factors, any other reports that came from another county, another city, another town, another state, another country, another continent, any other factors. There's a police report that says you did this. There's a police report that says you recently moved and you were the one who bought a rented truck from U-Haul, and you were the only driver in that truck driving to the new location. So the question becomes, who the hell was going to unload it? Okay. All right. Number 4. This is going into another subsection, but not of the original elements. How we determine the extent to which symptoms such as pain affect your capacity to perform basic work. Okay. Activities, so basic work activities, like, can you go to work? Can you do the functions of what you have to do at work, etc. In determining the extent to which your symptoms, such as pain, affect your capacity to perform basic work activities, we consider all of the available evidence described in paragraph C1 through C3 of this section We will consider your statements about the intensity, persistence, and limiting effects of your symptoms, and we will evaluate your statements in relation to the objective medical evidence and other evidence in reaching a conclusion as to whether you are disabled. So what they're saying is they're trying to figure out what evidence you have that's supportive of you, what evidence you have of, things that show that you're not disabled. They're really closely looking at the evidence that shows that you truly are disabled, because they know in that evidence you might have been bullshitting them or finding a way to make it when it wasn't really that situation. So let me give you an example. Let's say that, you weren't really that bad, but you went out and got a prescription for a walker with a seat or a wheelchair, right? And then at the same time, when they send up an investigator to go look at your setup, your house, your front door, guess what? There's steps going into it. And let's just be fair here. There's steps going into the back of it. And you only own one wheelchair. You don't have one in the car. So then the question becomes, well, how the hell do you get out and get around? Are you able to just use a walker? Do you have another walker? Where's the wheelchair? When they get into your house and look at the wheelchair and see that there's a bunch of blankets on it and it's dusty, you guessed it, they're going to be like, what the F is this? Apparently, you don't need this. That was a real case, by the way. The investigator on behalf of the SSA got into the person's house, saw that basically the wheelchair was dusty and had a bunch of blankets on it. Ergo, the person appeared to be a bullshit artist. Now, with that said, I hope you enjoyed this video where we go over essentially when the SSA uses elements to see if somebody is a liar, what those elements are, and how you can understand what they mean. Please remember to like. Please remember to subscribe. Head over to Google. Type in Disability Resolution Law Firm, Disability Resolution Florida, right? Throw some stars up there for that disability resolution. I've worked for that company for a long time. Now, with that said, I go live on Mondays and Thursdays. And if you need a 1-hour private session, mini contract is below in the bio. I will catch you a little bit later. You have a wonderful night, and we will go from there. Attorney Walter Hnot, thank you so much. Have a wonderful day. Bye-bye, everybody. Bye-bye.